We seem to be flying through November, and Thanksgiving is almost here. Good afternoon, and welcome to the Federal Society's Seat at the Sitting for December. I'm Nate Kazmarek, Vice President for Practice Groups and Networks. It's a delight to be with you. A programming note before we start. Earlier this month, we hosted our largest and most successful National Lawyers Convention to date in Washington, D.C. If you missed any of the more than 30 thought-provoking discussion panels and speeches from that weekend, they are now available for your viewing on our website, fedsoc.org. For today's program, we've put together a great panel of legal experts, as you've come to expect, to preview the oral arguments at the court for the next month. This panel will cover the cases and take audience Q&A in 90 minutes or less. As always, our usual disclaimer applies. The Federal Society doesn't take positions, and all views expressed in this session belong to our speakers. It's certainly a pleasure to welcome our moderator, Jill Jacobson. Jill, how are you?
I'm good. How are you? Thanks for having me.
Oh, well, we're delighted to have you. Appreciate you making the time. Jill is a litigation associate at Weil Gotshal. She is a former law clerk to Judge Eileen Cannon on the District Court for the Southern District of Florida and a future clerk for Judge Lisa Branch on the Court of Appeals for the 11th Circuit. Jill was previously a visiting fellow with the Independent Women's Law Center and a contributor at Young Voices. Her JD is from Boston College Law School, and she has a master's from Northeastern University. Complete bios for Jill and our panel are available for your review in the Zoom Resources tab on our website. I'm sorry, in the Zoom Resources tab or on our website. So you can check out all of their careers there. Towards the end of the webinar, we'll open it up to the audience. So please think about the questions for our panel. For those joining us via Zoom, questions can be submitted with the Q&A function at the bottom of your screen. Jill, many thanks. The floor is yours.
Okay, thanks for that warm introduction, Nate. And as always, thank you to the Federalist Society for having us here today. I'm looking forward to moderating what I'm sure will be a great discussion on the cases that will be heard this December. As a disclaimer, as Nate mentioned, I will wait to use the audience questions until the very end of the program, but you're welcome to submit them throughout the conversation through either the Q&A or the chat function. So I will begin briefly by introducing all of our panelists. First is David Casassa. Mr. Casassa is an associate at Gibson Dunn in their Washington, D.C. office. He practices in the firm's appellate and constitutional law, as well as the administrative law and regulatory practice groups. David graduated from Harvard Law School and then served as a law clerk to Justice Samuel Alito on the Supreme Court and for Judge Jennifer Elrod on the Fifth Circuit. We also have with us Boyd Garrett, who is an associate at Wiley-Rein in Washington, D.C. Before Wiley, Boyd also attended Harvard Law School and then clerked for Judge Richard Leon on the District Court for the District of Columbia. Next, we have Caleb Kruckenberg, who is the litigation director at the Center for Individual Rights. He previously worked as a prosecutor, a public defender, a lobbyist, and most recently as an impacts litigator at both the Pacific Legal Foundation and the New Civil Liberties Alliance. Caleb graduated from Temple University School of Law. Following Caleb, we have Professor Michael Morley. Professor Morley is the Sheila M. McDevitt Professor of Law at Florida State University. Prior to his experience in academia, Professor Morley served as Special Assistant to the General Counsel of the Army, as a law clerk to Judge Tejoflat on the 11th Circuit, as an associate at both Williams & Connolly and Winston & Strawn in Washington, D.C. Professor Morley earned his JD from Yale Law School. Next, we have Professors B. Rosen. Professor Rosen is an associate professor at the UNH Franklin Pierce School of Law. He has also taught at Southern Illinois Law Center, Hofstra University, and George Washington University School of Law. Mr. Rosen received his JD from Northwestern and his LLM in intellectual property from GW. He's practiced at Fried Frank as well as smaller firms and clerked for Judge Thomas Bennett in the Bankruptcy Court for the Northern District of Alabama. And last but not least, we have Joel Nolet, who is also an associate at Wiley in DC. Joel graduated from the Georgetown University Law Center and clerked for Judge Raymond Grunder on the 8th Circuit, as well as Judge Timothy Kelly on the District Court for the District of Columbia. So those are our wonderful panelists. We will start off with 5 to 10 minute overviews of each of the cases that will be argued this December, and then we'll transition into a conversation with the entire panel, and I will take any audience questions. So Caleb, let's have you take it away.
Well, thank you so much. And I'm happy to start on a case that could go either way. Next Monday's argument in Urias-Orellanos versus Bondi, excuse me, presents a question concerning the proper scope of review in an asylum case. And more technically, the question presented is whether a federal court of appeals must defer to the Board of Immigration Appeals judgment about a given set of undisputed facts and whether that is sufficient to constitute persecution under law. Now, kind of lost in this very dense language is what really makes this case interesting, and that's whether Chevron deference, or at least what's left of Chevron deference, still applies or should still apply in the federal asylum scenario. And that's because there's a long-standing circuit split about whether a court of appeals reviewing a denial of an asylum claim owes substantial evidence review or some sort of mixed deference to fact-finding undertaken by either the immigration judge or the Board of Immigration Appeals itself. So and while again that is sort of a very dry question, if we look back at the history of the substantial evidence review question that has been percolating, that all comes back to Chevron. And as we know, Chevron has now been overturned, at least in the context of administrative adjudication. So what's interesting about this case, though, and ultimately why I said, while it could go either way, is the United States, unsurprisingly, plays this very close to the vest. Um, it- Really, in short, there's a statutory term of art for asylum. And whether or not someone has suffered persecution in the past is a mixed question of law and fact, which adds up to a bunch of question marks here because the explicit standard of review is merely for judicial review in an appropriate court of appeals. Findings of fact are given deference, as is typical, but questions of law are given de novo standard of review. As I said, because of Chevron's lingering legacy, a certain number of circuits, including the First Circuit here, apply an extra substantial evidence layer of deference, which essentially comes out to whether the immigration judge thinks these things add up enough to persecution. And the original justification for this, rather than the statutory terms, is Chevron deference and the purported deference that a court owes to an executive officer in immigration contexts. As I said, the US's response is very restrained here, and they don't mention Chevron deference once. Unsurprisingly, in John Sauer's role as Solicitor General, he is not advocating that deference applies at all. He's instead making a sort of more nuanced statutory argument about how the proper role of a federal court really does defer to factual findings, and this is more of a fact question. Monday's argument, I think, is really going to be telling, and it's going to be telling to see whether the justices keep it narrow or whether this really will be a larger question about Chevron deference in the immigration context or even in even larger contexts. The U.S., I'm sure, hopes that will not be the case, but I'm very interested to see how this argument turns out.
think you were muted there, Jill.
Apologies. I said we'll have Professor Rosen next.
Howdy, everyone, and welcome to a discussion of a case that, while perhaps it's not the most politically salient case, I think is a really important case for the digital economy. And indeed, it's been treated as such. This case gives us a rare opportunity where the Trump administration and the ACLU are on the same side. Naturally, I wrote an amicus brief on the opposite side. So this case started a while ago now, where BMG, the music label, sued Cox Communications over illegal downloading by Cox Communications users. Cox is an ISP in the southern part of the United States. Typically speaking, internet service providers are immunized from liability under Section 512 of the DMCA. Section 512 of the DMCA requires that those providers have, among other things, a repeat infringer policy. And an internet service provider is typically not liable of the infringement by its users if they don't know about it and may have such a policy. Well, earlier in the course of this litigation, Cox lost this 512A immunity shield. Discovery in this case was rather interesting. There were emails among Cox Communications where they said to wit, F the DMCA, and the Fourth Circuit upheld that and found that Cox did not have liability shield. So now that we're through that, that's why these cases are fairly rare. You'd think they'd be more common, but because they usually 512A stops them, it didn't happen. Either way, that liability shield doesn't exist. And the other question is, has Cox committed vicarious or contributory infringement because of the downloading activity of its users? Now, below, I think the trial court found both vicarious and contributory. The Fourth Circuit said there was no vicarious infringement. That is where you have the right and ability to control, and you profit from the infringement. So they don't have that. Vicarious is sort of a version of respondeat superior. However, the Fourth Circuit did hold that now Sony, which has acquired BMG, had pled a cause of action under contributory liability. Cox has now appealed to the Supreme Court to say, no, there can't be contributory liability either. Now, contributory liability has a couple of different flavors. One version of it is so-called inducement liability, which we saw in the Grokster case. Those of you who remember Napster, fondly or otherwise, will remember that. But there's also this other side where if you know of the infringement and you've made a material contribution, discovery has shown that Cox clearly knew of the infringement. So the first question presented is whether acting as an ISP as part of infringement is making a material contribution or not. The second question presented is whether or not the infringement is willful. Now, willfulness is not a question of liability generally, but a question of damages. So the Copyright Act, Section 504, provides that, generally speaking, statutory damages, which are only available for works that are registered before the infringement, can go from $750 to $30,000. However, where the infringement is willful, the maximum is $150,000. So you can see how Cox would be eager to avoid that conclusion. An earlier damage amount was over $1 billion. So there's a lot of money at stake. The background here is basically whether the Second Circuit case called Gershwin versus Columbia Artist Management, which held that a company that books singers into venues was liable for the infringement of these singers where they were a booking agent. And they've applied this material contribution test fairly broadly. In return, Cox is saying, no, you look at the common law reasoning. In other words, you look at, well, is there a secondary liability under a more general common law test? So it's basically a question of common law standards of more general contributory liability in tort law or copyright law. Now, the reverse side is basically to say, well, if you have Section 512A and you have a situation where you have a liability shield, unless you adopt a repeat infringer policy, there is almost never going to be a liability for an internet service provider unless they have actual particularized knowledge of the infringement. I don't have to tell many people here that the internet service provider is rarely going to have particularized knowledge of individual user infringements because they're really operating at a mass scale. As for willfulness, it's a difficult test in that it's, generally speaking, it's going to be willful where they ever know of it or they recklessly disregard the copyright owner's rights. And so the question is going to be, to what sense has Cox done that? Sony is basically saying, but their emails. Cox is saying, hey, look, some of our employees might not have behaved ideally, but we haven't done that. So effectively, the ACLU and others have some concern. Some of you that's saying that you're basically going to lead to disconnecting people from the internet. Part of the subtext of this case is a statement, and some amici have said this explicitly, that the deal that was struck in 1998 regarding copyright of the internet, basically saying that internet service providers agree to have a repeat infringer policy that will include termination of subscribers. And Section 512 does say termination of subscribers is no longer workable in an era where the internet is ubiquitous and required. The response of the copyright industries is to say, we understand that, but the response to that is to go to Congress. And in any case, we're in an era where the rights of copyright holders are more impaired than ever de facto by copying on the internet, and that the court should not basically take all liability for copyright infringement away from internet service providers and allow them to just frankly let people spend lots of money on hosting on service plans so they can engage in large scale piracy, and the ISP will never be liable. So interesting and important case, and I'm curious to see how it goes. Thank you.
Thank you, Professor. Now we'll move to First Choice Women's Resource Center versus Platkin to be discussed by Joel Nolet.
Okay. Thank you so much, Jill, and it's great to be here with you all discussing the upcoming cases. First Choice Women's Resource Centers Inc. versus Platkin. Very interesting case because it kind of sits at the intersection of several recent Supreme Court decisions. Just by way of background, briefly, the First Choice is a crisis pregnancy center that operates in the state of New Jersey. Basically, in a nutshell, providing an abortion alternative for women who find themselves in those circumstances. The New Jersey Attorney General, in the wake of the Dobbs decision overruling Roe versus Wade, joined with kind of a cohort of a number of other states' attorneys general to pledge to kind of crack down on these crisis pregnancy centers, based upon allegations that they were maybe hoodwinking women into thinking that they were providing certain services, that they were basically like a Planned Parenthood when obviously they're not. And on that basis, they decided that they would go after some of these crisis pregnancy centers who in their view were bad actors of sorts. And so the New Jersey Attorney General issued a subpoena to First Choice. And in that subpoena asked for a litany of information, in particular about who their donors were. And again, this was kind of on a theory of consumer protection, and the theory of the subpoena to support its issuance was that this First Choice Women's Resources Center had one website where they were raising funds, but they were not making clear on that website that who they were in the course of raising those funds. And so the New Jersey Attorney General pursued this theory that they might be deceiving certain donors into thinking they're donating to something that they weren't quite fully aware of what it was. Now, this, if this sounds perhaps a bit familiar, you have a government agency looking to get donor information from a nonprofit. It's because in the Americans for Prosperity Foundation versus Bondi case from just 3 years ago, I think in 2021, that was essentially the facts of that case, where the California Attorney General had been, under a tax scheme, had been looking to get donor information about the Americans for Prosperity Foundation. So First Choice, quite understandably, filed suit in federal district court under 42 U.S.C. 1983, kind of the default federal civil rights statute, alleging that the subpoena was unconstitutional under the First Amendment, primarily because it imposed an unconstitutional chill on First Choice's speech and associational rights. The Supreme Court has recognized for many decades. That's when things got interesting, because the Attorney General, with that 1983 lawsuit pending in federal court, the Attorney General then went to state court to try to enforce the subpoena to get First Choice to try to comply with it. And that led to a ping pong, if you will, back and forth, where you had these kind of two-track proceedings. Ultimately, what happened is relevant for the Supreme Court case is that the federal district court concluded that until all the issues, in the First Amendment objections got resolved in the later filed state court litigation that was filed by the New Jersey Attorney General to enforce the subpoena, until that state court litigation ran its course, First Choice's constitutional claims were not ripe constitutionally for purposes of Article III standing doctrine in federal court, and so said that it lacked subject matter jurisdiction and couldn't hear the case. Matters continued to transpire in state court. There was a lot of back and forth. The state court judge ordered the New Jersey Attorney General and First Choice to meet and confer and try to negotiate to narrow the subpoena. The state court, however, never actually has not yet gotten to the First Amendment questions that in the state court litigation First Choice raised as defenses to the enforcement action. Meanwhile, First Choice took up their federal district court case that had been dismissed up to the Third Circuit, and the Third Circuit affirmed the dismissal, more or less agreeing with the reasoning and in a short per curiam with Judge Bevis dissenting in a footnote. But the Third Circuit essentially agreed that the case was not constitutionally ripe, that the state court litigation needed to run its course before the federal lawsuit could be brought. Now, the kind of, I guess, the third Supreme Court case that of recent vintage that is implicated here is Nick versus Township of Scott. That arose in the Fifth Amendment context, but the Supreme Court, since the 1980s, had crafted this prudential exhaustion requirement, or a state court litigation requirement, it was often referred to, where, in a nutshell, if you wanted to sue for inverse condemnation when a state government entity comes to take your property, you had to pursue that relief in state court. You couldn't just go and file immediately in federal district court. And that led to this, preclusion trap is the term in particular, what the parties refer to it, what the court later referred to it, where if you litigate in state court and you lose, that state court judgment is then res judicata. And so you can't go to federal district court and bring your lawsuit, your constitutional claim, because the federal district court is bound constitutionally to give effect to the state court judgment that rejected your constitutional claim. In Nick versus Township of Scott, the Supreme Court, I want to say back in 2018, but sometime recently, overruled this state court litigation requirement, this prudential exhaustion requirement, and said, no, you can go ahead, and if you have a constitutionally ripe claim, you can go ahead and file it in federal court. There is no prerequisite that you first pursue state court litigation and exhaust, so to speak, your state court remedies before going to federal district court. So that is the posture, and that's kind of the legal framework and the relevant legal principles at issue. After First Choice's after its lawsuit in federal court got, the dismissal got affirmed by the Third Circuit, it then filed a cert petition. And I think that's the question presented is up there, but they asked the court to answer and decide where the subject of a state investigatory demand has established a reasonably objective chill of its First Amendment rights, is a federal court in a first filed action deprived of jurisdiction because those rights must be adjudicated in state court. Now, based upon the discussion of the background and the legal framework kind of governing this case, based upon that question presented, you might think that to ask the question is to answer it. The Supreme Court just decided this in Nick, Americans for Prosperity. You have this chill from a like a government subpoena, or at least an analog in the context of the AFP case. So no, you don't have to go to state court first. Of course, the first filed federal court lawsuit can proceed and does not have to be dismissed on constitutional ripeness grounds. What's interesting is that the New Jersey Attorney General did not really quibble after the Supreme Court granted cert. The New Jersey Attorney General didn't really quibble with that question presented, and in fact, more or less agreed, saying yes, when there is an objective chill under Nick versus Township of Scott, you can go ahead and file in federal district court. You don't have to pursue state court litigation first. What the New Jersey Attorney General instead argued was that there is no objective chill in this case, and has tried to refocus in its response brief on the merits to arguing that First Choice has not established under the First Amendment that there is a chill of its speech and associational rights that could give rise to a sort of concrete injury that is actually imminent and thus meets the standing requirements to be able to be pursued in federal court. So on the one hand, this case, seems like it presents all these issues that the court has just recently decided, and should, the conclusion should follow logically. On the other hand, oral argument could kind of go sideways, and this case could really just become an argument about what is the requisite standard, what do you have to show to establish objective chill, and does the subpoena, especially in light of the state court negotiations and how it's been narrowed since the start, is there objective chill in this case? It'll be very interesting to see where the justice's focus is at oral argument.
Thank you, Joel. Next, we'll move to Olivier versus City of Brandon, Mississippi, with David Casassa.
Thank you, Jill. I should start by noting that I'm one of the counsel representing the petitioner in this case, but I'm going to do my best to give a neutral overview. It's interesting to have this argued the day after First Choice, because Olivier versus Brandon is similarly a case about the interplay between federal and state courts and between different federal avenues to challenge state action. So in this case, it's really about the overlap or non-overlap between Section 1983, which provides a general framework, a general federal claim and law or equity to challenge state action that's undertaken in violation of a federal right, including federal constitutional rights. And on the other hand, the federal habeas regime, which creates a very detailed and highly regimented system that folks convicted under state law have to go through in order to bring a federal court challenge for relief from their state court conviction. So typically that's a writ of habeas corpus for release from state confinement. And in fact, the habeas statute says that someone in confinement under color of state law may petition a federal court for a writ of habeas corpus. And the court has developed over several decades now a series of cases that tries to reconcile these two regimes to one another and to lay out which avenue you have to use to get which form of relief. So starting in the 1970s in a case called Pricer, the Supreme Court held that a person in prison, in that case, bringing a constitutional challenge to the calculation of good time credits can't seek an injunction that would result in his release from prison. So you can't use 1983 in order to get an injunction requiring the state to unwind the effects of your conviction. A couple decades later, and interestingly, in that decision, in Pricer, the court in passing says, but of course you could seek damages because that's a different form of relief and it's not unwinding the effects of the conviction. A few decades later, in a case called Heck versus Humphrey, the court considered that exact question. A prisoner who was being held pursuant to a state conviction filed a 1983 challenge saying that their conviction was unlawful and that they were entitled to damages because of the state's unconstitutional action in imprisoning them. And the court looks at the relationship between the two statutes, and also importantly at the common law backdrop for the 1983 claim. And the court says that the 1983 claim here is drawing on this common law tradition of malicious prosecution. And one of the essential elements of a malicious prosecution tort is being able to establish that the prior criminal proceeding resulted in favorable termination. So you were acquitted, or you were prevailed on appeal, or were pardoned, or any of these outcomes, that there's some independent showing that the prosecution was wrong or unlawful or did not result in a proper conviction. And the Supreme Court in Heck says, in the absence of that, you cannot satisfy a 1983 claim that is targeted back at compensating for the fact of your conviction. So that, on the one hand, there's the Pricer line of cases about injunctive relief that attacks your conviction, and then the Heck line of cases about damages claims. And that brings about Mr. Olivier's situation. So Mr. Olivier is a street preacher who stands out in public spaces and preaches to passersby his view of the gospel. And he likes to do this in outside amphitheater in a public park in Brandon, Mississippi. The city has passed an ordinance that purports to restrict where people can conduct protests in the park. So instead of standing where most of the people are likely to be passing by and to see, the city has moved the protest zone effectively to one corner of a back parking lot. So most people will just never have cause to pass by or see. Mr. Olivier went to preach outside the amphitheater, and the police told him to go to the protest zone. He went and decided it wouldn't be effective to preach there. So when he came back outside the amphitheater and began preaching, he was arrested. And he was convicted of violating this ordinance. He paid a fine, and he did not appeal his conviction. But then he later brought a 1983 case seeking protection against future enforcement of the same ordinance. So he wants a declaration and injunctive relief saying that in the future, the city can't bring a new prosecution against him for going out to preach again, if he's to find himself there speaking to the public. So both the district court and the Fifth Circuit found that this claim was precluded by the rule of Heck, and specifically by the way the Fifth Circuit has interpreted the line of Heck cases. Heck itself, in describing what it was doing, says that you can't bring a 1983 claim when success on the 1983 claim would necessarily imply the invalidity of the conviction. And in the Fifth Circuit's view, any 1983 claim, including one for future relief, what we would typically call a pre-enforcement challenge, is a claim that would imply the invalidity of the prior conviction and therefore can't be brought. The Fifth Circuit is a relative outlier in this. Most courts have not even adopted a definitive position on this, and at least two others had said, when you're seeking prospective relief, you're just outside of the realm of Heck because you're not trying to attack your conviction in any way. You're just bringing a standard 1983 pre-enforcement challenge. So Olivier petitioned on two different questions, both related to this Heck context. The first asks about purely prospective relief and asks whether a 1983 plaintiff bringing a classic pre-enforcement challenge seeking to be protected against future enforcement of a law is barred from litigating that claim solely because he was previously convicted of violating the law. It's a little peculiar that the Fifth Circuit has said you had. Typically, courts often in the standing context say if you haven't been prosecuted for violating a law in the past, you can't establish Article III standing. So as some of the dissenting judges in the Fifth Circuit said, this puts you in a bit of an awkward catch-22 where on the one hand, you might not have a 1983 claim if you have been prosecuted, and on the other hand, you couldn't show Article III standing if you hadn't been prosecuted. And the second question presented asks about whether Heck applies to a plaintiff who, in Olivier's case, has never been in custody, or, as some circuits have weighed in on, to a plaintiff who may have been in custody in the past but isn't currently. So that is an issue that has deeply divided circuits. Nearly every circuit has weighed in. They're basically equally divided about it. And it's really about the statutory conflict there. So habeas is only available to someone in custody. If you're not in custody, you cannot bring a habeas claim. So the circuits that have ruled that 1983 is available say you should have some federal forum for this claim. And the circuits that have ruled against that have said that even if you have been released, even if you're have never been in custody, you still shouldn't be able to use 1983 as a means of undermining your prior conviction. So there are a lot of different avenues that the court could take in this case. Interestingly, the United States is participating as an amicus and encourages the court to rule for the petitioner on question presented 1 and to say that prospective relief just falls outside the scope of the Heck versus Humphrey standard. And 1983 allows a plaintiff, including a plaintiff with a prior conviction, to come into court and seek protection from future prosecution. On the other hand, the United States takes the side of the city on the second question presented and says that the mere fact that someone is no longer in custody does not revive a 1983 claim that should have been governed by the regime of habeas in the first instance.
Thank you so much, David. Next, we will move to Professor Morley to discuss the either much awaited or very nerve-inducing case, Trump v. Slaughter. Professor, I suspect you might be muted.
Thank you. Thank you very much. So the case begins back in 2018 when President Trump nominated Democrat Rebecca Slaughter as a commissioner of the Federal Trade Commission. She was unanimously confirmed to serve the remainder of a 7-year term, which was set to expire in 2022. President Biden then renominated her, and she was unanimously confirmed to yet another term that was set to expire next year in 2026. This past March, she, along with another commissioner who subsequently resigned, received emails containing a notice from President Trump that she had been removed from the FTC effective immediately. The letter stated, quote, "Your continued service on the FTC is inconsistent with my administration's priorities. Accordingly, I am removing you from office pursuant to my authority under Article 2 of the Constitution." After receiving that email, Slaughter was denied access to her office, official files, her email account, and was changed to being a former commissioner on the FTC website. So she sued President Trump, FTC Chair Andrew Ferguson, another holdover commissioner who remained on the commission, as well as the FTC's executive director, seeking, among other things, an injunction and a writ of mandamus that would bar the defendants from taking any action to prevent her from serving her duties as a commissioner. The main argument underlying all of the causes of action in her lawsuit is that Section 1 of the Federal Trade Act provides that FTC commissioners, quote, "shall be appointed for terms of 7 years, and people who are appointed to fill vacancies, quote, shall be appointed only for the unexpired term of the commissioner whom he shall succeed." In addition to setting out terms of years, the statute goes on to say, quote, "any commissioner may be removed by the president for inefficiency, neglect of duty, or malfeasance in office." No such allegations were made in this case. Mere political disagreements are not included in the statutory list of grounds for removal. The FTC itself was established as an independent agency that was supposed to operate free of political oversight so that it could ostensibly base its decisions on objective, expert, technocratic grounds. And as the commissioners served longer terms, they in fact would gain more experience and be able to bring more expertise to bear. And of course, the FTC was established as a bipartisan commission, of which no more than 3 commissioners could be of the same political party. And this bipartisan structure would be undermined if the president were free to fire any commissioners who he or she wished based on pure policy disagreements. So Slaughter moved for expedited summary judgment and a permanent injunction in federal district court, relying heavily on a precedent I'll talk a little bit more about in a few minutes, Humphrey's Executor versus United States, which had recognized Congress's power to prevent presidential removal, specifically of FTC commissioners. The government made two main arguments in response. Right? First, the president has inherent authority under Article 2 of the Constitution to remove FTC commissioners, and so to the extent that the FTC Act purports to limit or restrict that authority, it's unconstitutional, and the court's ruling to the contrary in Humphrey's executor should be overturned. And then in the alternative, even if the termination was invalid, right, even if the president doesn't have unlimited authority to remove FTC commissioners at will, a federal court, the government argued, lacks power to order reinstatement of principal executive officials, so that even if the termination was wrongful, the correct remedy would be limited to things along the line of back pay rather than restoration to office. And in any event, the government went on to argue that the plaintiff didn't suffer irreparable harm, warranting extraordinary or equitable relief, precisely because she could later sue for back pay. The district court agreed with Slaughter, issuing an injunction requiring the other FTC commissioners, as well as the executive director, to allow her to continue performing her duties as a commissioner. After a brief administrative stay, the D.C. Circuit declined to stay on the merits of the district court's order, holding that Slaughter was likely to succeed in light of Humphrey's executor. But about 4 months ago, the Supreme Court stayed the district court's injunction and granted certiorari on both main issues. On the one hand, should Humphrey's executor be overturned? And then secondly, can a federal court prevent a person's removal from public office? So this case occurs against the backdrop of two major Supreme Court precedents. So when I told you that this case began 8 years ago, it really began, like many good legal stories, a century ago, back in 1926, in the Supreme Court case of Myers v. United States, in which the Supreme Court held that Congress can't limit the president's authority to remove postmasters by requiring that the Senate give advice and consent to such removals. Myers had held, among other things, that the Article 2 vesting clause, which vested executive authority in the president, as well as the president's constitutional power and duty to take care that the laws be faithfully executed, required the president to be able to remove executive personnel at will. Reviewing debates in the first Congress over the initial establishment of the principal executive departments, Myers went on to discuss the so-called Decision of 1789, in which, as James Madison had urged, Congress arrived at the conclusion that the Constitution gives the president sole power to remove executive officials at will. Based on those debates leading up to the decision of 1789, the Foreign Affairs Act, as passed by Congress, assumed that the president could remove the Secretary of State. So it wasn't even a matter of Congress as a policy matter choosing to confer that authority, but rather, as Myers reads the act, the Congress was recognizing the president's inherent, already existing constitutional removal power. So about a decade after Myers, the Supreme Court decided Humphrey's executor, in which, notwithstanding Myers, the court upheld the constitutionality of the FTC Act's restrictions on presidential removal of FTC commissioners. In that case, President Roosevelt had fired a Republican commissioner, William Humphrey, who had opposed the New Deal and who opposed the commission's efforts to engage in vigorous antitrust enforcement against private companies. And about 5 months after his termination, Humphrey died. And so the executor of Humphrey's estate sued the federal government in the Court of Claims, seeking back pay for the 5-month period between Humphrey's between Humphrey's termination and his death. And the U.S. Supreme Court ultimately held that the termination was invalid because it violated the FTC Act's restrictions, and those statutory limits, the same that remain in effect today, those limits were valid because Congress had the constitutional authority to limit the presidential's removal power over commissioners. The court explained that FTC commissioners did not exercise true executive power, but rather quasi-legislative and quasi-judicial powers. Unlike today, at the time, FTC commissioners were limited on the one hand to subpoenaing information from regulated industries, investigating industries, putting together reports and studies, all sorts of quasi-legislative functions that could support the development of possible amendments to federal law, and for the most part, things that Congress would have constitutional authority to do itself. And on the other hand, the commission at the time could perform formal adjudications, making findings of fact and issuing cease and desist orders against particular respondents. And the court characterized this as a quasi-judicial function. And so therefore, in the court's view, the commission at the time was not exercising executive power. Therefore, Congress was free to limit the president's authority to remove FTC commissioners. Of course, over the near century since that ruling, the FTC's powers have greatly expanded. In particular, the commission has gained power to promulgate binding substantive regulations in order to implement, interpret, and enforce various legal provisions, and can also sue in court to seek remedies, to seek civil remedies, including injunctions and restitution for customers who have been harmed by violations of the act. And so one of the main issues that the court will have the opportunity to consider is whether these new grants of authority, these new substantive powers that the commission has, are enough to render it an executive agency. Now, one of the important things that makes the backdrop of this case even more favorable for the government is that as these issues were evolving, the president dismissed members of several other ostensibly independent agencies. In particular, the president dismissed members of the National Labor Relations Board and the Merit Systems Protection Board, who went to court, challenged their terminations. A district court entered injunctions ordering their reinstatement, but in Trump v. Wilcox, the Supreme Court held that the government was likely to succeed on the merits in being able to demonstrate that the government has authority to terminate them, precisely because both agencies have considerable executive authority. And in Trump v. Boyle, the Supreme Court has likely stayed an injunction that would have required the reinstatement of a member of the Consumer Product Safety Commission who President Trump had terminated. And again, that case raised very similar arguments. So going into the court's consideration of the case, the backdrop looks very favorable for the government. There are, as I had said before, the court's going to be addressing two main issues. The first, with regard to presidential removal authority, right? As we discussed, Myers already recognizes that the Constitution gives the president power to remove executive officials. Congress cannot impose limits on that power. So if the court wants to rule in the government's favor, one question is whether the court will simply expand Myers to apply either to all principal officers of the United States or potentially even all officers of the United States, which would require that Humphrey's executor be overturned. Or instead, as I alluded to before, the court could simply distinguish Humphrey's executor. The court could say that Humphrey's executor is inapplicable today precisely because the modern FTC is so different from the commission as it existed at the time of Humphrey's executor that it has become an executive agency that falls within Myers rather than Humphrey's executor. This approach would leave Congress room to limit the president's removal authority over certain sorts of officers, particularly those deemed to exercise truly quasi-legislative powers or quasi-judicial powers. Of course, those terms might not survive the court's ruling in Humphrey's executor if the court chooses to go further in actually overturning that case. And then the second issue, which I'm happy to delve into in the Q&A, assuming that restrictions on the president's removal power are valid, the question then arises, what relief can courts give? In Humphrey's executor, of course, the removed commissioner had died, and so there wasn't a question of reinstatement. It was only a case for back pay. And so the court will assess whether extraordinary remedies at law or in equity, such as writs of mandamus, quo warranto proceedings, or injunctions, are available mechanisms that federal district courts can use if they conclude that a presidential appointee has been wrongfully removed in violation of a constitutionally valid restriction on the president's removal authority.
Great. Thank you so much, Professor. Last but not least, Boyd Garrett will discuss National Republican Senatorial Committee versus the Federal Election Commission.
Thanks, Jill, and thanks to the Federalist Society for hosting this panel. So the NRSC versus the FEC is a campaign finance case, and it's specifically about the extent to which the government is able to limit coordinated expenditures between a political party and its candidates. And so the statutory provision at issue in this case is a part of the Federal Election Campaign Act, or FECA, and the provision places a cap on how much a party can spend in coordination with its candidates. And so under this cap, for example, if the NRSC wants to support a Senate candidate in a race, it can contribute directly to that candidate, or it can spend in coordination with that candidate only up to a certain amount. And the amount, for the Senate, it's kind of a complicated formula based on the population of the state. For the House, it's a uniform limit that adjusts with inflation. But after that limit, the party can only spend money independent of the candidate. So they're not allowed to, check in with the candidate and work with them to decide how best to allocate their resources. Again, once they reach the cap. So just kind of stepping back for a moment, this scheme seems a bit odd, at least to me, because when I think about what a political party does, it is kind of by definition working closely with candidates to get them elected to office and to get the candidates to adopt the party's ideas, and vice versa. That just seems kind of part and parcel of the electoral process. And so that kind of begs the question that's, I think, really central to the case, which is, well, then why did Congress do this? What are these limits for? And the legislative history suggests that Congress wanted to deter what it saw as wasteful spending. And the problem with that understanding of this provision is, in the First Amendment context, the Supreme Court has said you cannot limit electoral advocacy unless there's corruption, quid pro quo corruption, or its appearance. So wasteful spending would not be a permissible reason to restrict the speech or funding and aid of speech of political parties. So the argument that's been put forward for how this prevents corruption or its appearance is this kind of anti-circumvention theory. So take for a moment as a given that if an individual person contributes to a candidate, that can be limited to prevent corruption or its appearance. And so the argument is that, well, maybe you could evade that limit if you use the party as a middleman. So the person would contribute as much as they could to a candidate up to the limit, then they would contribute more to a party, and they would tell the party, oh, we'll spend this money on this candidate. And then they could tell the candidate, oh, well, look, like I actually spent more than the contribution limit on you via the party. That's the theory. That's the argument about how this relates to corruption or its appearance. So the kind of with that background, the NRSC, the NRCC, and its candidates challenged the constitutionality of this cap in the Sixth Circuit. And they made a couple of arguments for why the government can't satisfy First Amendment. So what they initially say are, kind of like the threshold is like, there's just not a legitimate or a substantial government interest that's been proven by the record. And they say on this anti-circumvention theory, that's a nice theory, but there's not evidence that this is happening. There's not evidence that people are going in and they're using the parties as middlemen to circumvent the contribution limits. So they say, the government has failed to meet its burden on interest to restrict speech. And in fact, it looks a lot more like what this provision is doing is kind of what's suggested by the legislative history, which is preventing, wasteful spending, which everyone agrees that, you can't win on that interest. And then they argue that to the extent this is a real concern, that, that the government's met their burden on, the tailoring is inadequate. And they just point out that what the scheme that the government is trying to go after is already illegal. And so, for example, there is this anti-earmarking rule in FICA that says when you give money to the party, you cannot tell them, give money to another person later down the chain. You can't earmark it. And so the circumvention theory, it's already illegal. It's like there's already something in place to prevent it. So this is a prophylaxis upon prophylaxis is what they argue and what some of the judges on the Sixth Circuit agreed with. And so they say you lose on tailoring. So then the FEC's response in the Sixth Circuit is to really rely heavily on a Supreme Court precedent. It's called FEC v. Colorado Republican Federal Campaign Committee. It was decided in 2001. It was a 5-4 case. And the challenge was a facial challenge to the coordinated expenditure cap. So the same provision here. And 5-4, the Supreme Court said for the facial challenge, you lose, and they bought into this anti-circumvention rationale. They didn't take a very rigorous look at the evidence, I would say, but that was the reasoning. And so the FEC says Colorado controls the case. So then sitting en banc, the Sixth Circuit agrees with the FEC that Colorado controls the case. Chief Judge Sutton writes the opinion, says, you know what, our hands are tied. But both that opinion and a bunch of the concurring opinions say, even though we're bound by Colorado, like this really seems inconsistent with the Supreme Court's modern First Amendment doctrine. And so they kind of tee it up for the Supreme Court that there seems to be a problem here. So Supreme Court grants cert on this. And there's been a couple of interesting developments. So, the underlying merits arguments are basically the same. But the FEC has declined to defend the law. They agree that this violates the First Amendment. And so they've now switched sides. So as a result, the court has granted an amicus to defend the judgment below. And they've also allowed all of the Democratic campaign committees to intervene in defense of the statute. And so in trying to mount that defense, there's also been some interesting developments. So the court-appointed amicus, they, of course, argue on the merits, but they spend about half of their brief on kind of procedural, arguably jurisdictional arguments. They argue mootness, and they argue that the parties failed to satisfy the direct review scheme, and so shouldn't have been able to bring the case in the Sixth Circuit, and just kind of a grab bag of different procedural things. And then the interveners spend a lot of time on the stare decisis factors. Again, it's half their argument is stare decisis factors for why the court should not overrule Colorado. And then, the other half kind of making the anti-circumvention type argument from first principles. So really kind of an interesting case here. And it's going to be argued on December 9th, and really looking forward to see what the court thinks.
Okay, thank you so much to our panelists for the great overview. So now I'm going to give very brief overviews of the 2 December cases for which we do not have a speaker, and then I'll open up the conversation for commentary on any of these cases or the ones that have been discussed so far. So if you have questions, now would be the time to submit them, either through the Q&A feature or through the chat. So The first case is Ham versus Smith, and the question presented is, when a capital defendant has taken multiple IQ tests with varying results, how should courts evaluate the cumulative effect of those scores to determine whether the defendant has significantly sub-average intellectual functioning under Adkins versus Virginia? So, as a reminder, Adkins held that the execution of the mentally impaired constitutes cruel and unusual punishment in violation of the Eighth Amendment, but Adkins largely left the particulars of how to determine mental incapacitation as an evidentiary matter to the states. So this question really is a question about who decides. Should this methodological evidentiary determination be left up to the states, or should there be a standardized approach given the inquiry's constitutional roots? So in this case, Smith is on death row in Alabama for intentional murder. He has received 5 IQ tests over the span of his lifetime, with scores spanning from 72 to 78. And Alabama requires an IQ under 70 to be considered mentally incapacitated, such that you couldn't be executed without running afoul of the Eighth Amendment. So Smith sought habeas review of his sentence on the argument that his various IQ tests should be read holistically, and that the tests are so unreliable that it's actually quite plausible that his IQ is lower than 70, particularly given that several of his tests were on the lower range. And the district court agreed, and they vacated his death sentence. The 11th Circuit affirmed and held that Smith only needed to prove by a preponderance of the evidence that his IQ is equal to or falls below that 70 threshold under Alabama law. They further reasoned that the court could consider all of his tests collectively, and because of the alleged error rates in those various tests and the numerous tests that fell on the lower end, he did show, based on a preponderance of the evidence, that his IQ is equal to or below 70. And so the real question is whether such a holistic approach is permissible, and whether there will ultimately be a state-by-state approach, or whether there will be one standardized approach. Obviously, this decision has huge implications for capital cases right now, and has, the possibility of vacating lots of sentences, given that taking multiple IQ tests in this sort of inquiry is quite common. So further, whether a defendant is deemed unable to be executed due to cognitive functioning is largely a state-by-state determination, meaning that there are times when the state that you happen to be sentenced in makes the capital determination, the harshest penalty that we have. So practically, this poses huge implications for the way that people are sentenced in capital cases, and it ultimately will change the way that expert testimony is offered on mental state, and lots of the other day-to-day decisions that the defense bar makes when assessing the viability and presenting these arguments. So that is that case. And then next we have FS Credit Opportunities Corp. Versus Saba Capital Master Fund. This case, on the other end of the spectrum, will decide whether investors can sue funds directly when those funds adopt policies that allegedly violate federal securities law. So this is purely a statutory matter, and it specifically asks whether Section 47B of the Investment Company Act creates a private implied right of action. So traditionally, the Securities and Exchange Commission has the authority to enforce the ICA, and private parties generally have no right to do so. But as we know, understandable, if there's explicit language suggesting that Congress intended to create an implied private right of action in a given statute, then there is an option for private parties to enforce things that are traditionally done by agencies like the SEC here. So the ICA provides in relevant part that a contract that is made or whose performance involves a violation of the ICA is unenforceable by either party. And to the extent that a contract described in paragraph 1 has been performed, a court may not deny rescission at the instance of any party unless such court finds that under the circumstances, the denial of rescission would produce a more equitable result than its grant and would not be inconsistent with other purposes of the ICA. And circuits are split as to whether that language creates a new private right of action or merely suggests a private remedy, that the remedy is rescission in the event that the SEC brings a right of action. This case appeals the Second Circuit's determination, which held that the ICA does provide a private right of action, and most funds that would fall under this, they litigate in the Second Circuit. So that has huge implications for the industry. And on the other side of the ledger are the Third and the Ninth Circuits who've rejected a private right of action for that lack of clear language understandable. So the task for the court is really quite narrow here. Does the language at issue have that rights creating language that we would typically expect? But while the task is limited, I think the decision will have broad implications for whether activist investors really have a vehicle to challenge fund management decisions, or whether this particular vehicle is just reserved for SEC use. I think this case sort of also reflects the Supreme Court's broader interest in addressing arguments about private right of action, which it's more recently taken an interest to. In Medina versus Planned Parenthood, for example, we found one such case where the Supreme Court declined to recognize a private right of action in a statute that really seemed more tailored towards agency action. So those are the remaining cases for this term. We will now open it up to general commentary and discussion. Again, if you have questions, please put them in the chat. So let's begin with audience questions. This question is from Brandon Beck, who says, the Third Circuit didn't spill much ink, if any at all, on Americans for Prosperity versus Bonta. But I'm assuming, Joel, this is for you. But what's the best argument for it not being squarely applied and dispositive in the first choice case?
Sure. So, to steelman it for New Jersey, the Americans for the regulatory scheme at issue in Americans for Prosperity Foundation versus Bonta was one that involved kind of mandatory disclosure. It was, a tax regulatory scheme that was, if you were registered in California, then you had to turn over certain donors that met certain criteria. And so there was no question that this disclosure was going to take place. And so the chill was pretty cut and dry. New Jersey's argument here is that we're talking about a subpoena that is, and they heavily emphasize the fact that it is an administrative subpoena, not a court subpoena. It's one that was issued by the New Jersey Attorney General itself, and it is not self-executing. I think that phrase appears like 50 times in their response brief. And they really emphasize that. So it's not self-executing, meaning that it's not this sort of mandatory disclosure regime akin to the regulatory scheme at issue in Americans for Prosperity. Rather, it's unclear whether or not there'll be any disclosure pursuant to the subpoena, because maybe First Choice will win. Maybe they'll narrow it to the point where any objectively reasonable chill, which is the standard under the First Amendment, that's gone. And so because it's still at this juncture tenuous and not clear cut, what will be disclosed and whether or not the scope of what will have to be disclosed would actually inflict a First Amendment injury. Therefore, Americans for Prosperity Foundation doesn't govern, and there is a lack of constitutional ripeness in this case.
Thank you, Joel. Next, I think we will go to Professor Morley. Professor, when you were discussing Trump versus Slaughter, you sort of posed the question, let's assume presidential removal is invalid. Now we have a secondary question of what is the proper vehicle to address when someone's been wrongfully terminated. So if you'd like to speak a little on that, that would be great.
Sure. So in other cases having nothing to do with the whole presidential removal issue, the court has said when we look at equitable remedies that federal courts can grant, we look at equity as it existed back in, depending on exactly what court ruling you want to use, either 1776 or 1789. Different court rulings have focused on different founding era moments in time. But either the moment of the nation's independence or the moment of the Constitution's adoption / adoption of the original Judiciary Act, which gave equitable jurisdiction to federal courts. So one of the questions becomes, okay, if a wrongfully removed official seeks equitable relief from a federal court, then to determine whether an injunction, for an example, would be an appropriate remedy, a court would ask, could the English Court of Chancery have issued an injunction restoring a wrongfully removed official to office back in 1776? And if not, then such relief is just categorically unavailable. If so, then the question becomes, is there then something about constitutional separation of powers or some subsequent constitutional developments that would prevent federal courts from being able to grant such relief? With regard to remedies at law, many equitable seeming type remedies actually originated from English common law courts, and so that's why some of the briefing, including my own briefing, dealt with extraordinary writs such as writs of mandamus, quo warranto, where again in England those would be the types of remedies that would have been available to restore wrongfully removed officials to office. Mandamus generally available if the office were still vacant. Quo warranto if a so-called usurper or pretender had filled the wrongfully created vacancy, and the court were determining that the petitioner had been wrongfully removed and had the right to retain office. So a lot of the court's analysis is going to involve historical excavation, looking at what were the uses of these various legal and equitable writs and orders in England in the 1700s, and then whether there's something unique about our particular constitutional context that would change in terms of how they apply in the federal office. I will say I do think it is unlikely that the court would say Congress can limit the president's power to remove federal officials, that such limitations do not violate separation of powers, they do not impede executive authority, but nevertheless, wrongfully removed officials are relegated to damages actions, or they're relegated only to substitutionary relief like back pay. My sense is the court is likely to address the substantive constitutional concerns, the substantive separation of powers concerns at the merits stage in determining the bounds of Congress's authority to limit the removal power. And then if it decides, notwithstanding those separation of powers concerns, Congress can limit the president's removal power, I don't think those concerns then are going to sneak back in at the remedies stage and relegate officials just to getting their back pay, like Humphrey's executor recovered. I think it'll more be a choice at that point in terms of what remedy. Is an injunction available? Probably not. Is mandamus or quo warranto available if the court goes there? I think based on the history, that's where it's likely to land.
Thank you, Professor. Now we will zoom out a little bit, and both Slaughter and NRSC versus FEC present questions that may well overturn longstanding precedent. Well, we can debate whether Humphrey's executor is still truly in play, but at least on paper, they both involve overturning precedent. And I think some people describe this term and last term as sort of the manifestation of the Roberts Court's perhaps increased willingness to overturn precedent and perhaps taking a different approach to stare decisis than we've seen in other courts. And so I think to the panel more broadly, do those two cases represent this trend? Is this trend even really an accurate depiction of what's taking place at the court? Perhaps Boyd or Professor Morley can start us off with respect to your specific cases.
Yeah, I'm happy to talk about the NRSC case. I mean, I will note, like, there's an argument that Colorado doesn't control this case because FECA has been amended since 2001, and I mean, obviously that didn't work in the Sixth Circuit. But I just want to point out that there's not necessarily a direct conflict with Colorado. But yeah, I mean, I do think like in the last 25 years, especially campaign finance has changed a lot. Like you've got Citizens United and McCutcheon and FEC versus Cruz. And I do think it is kind of hard to reconcile those cases with the cases from, even like the early 2000s, but especially before that. And I mean, I don't know if I would say it's a trend that the Supreme Court is overturning precedent, but I mean, I think it's looking a lot harder at that precedent. And I think it's, also thinking about like, what do we do with this precedent that's kind of inconsistent with how they understand the Constitution and how the Constitution was originally understood. Justice Kavanaugh had like a really interesting concurrence in Rahimi last turn, where he says that the original understanding of the Constitution can act as like a gravitational pull on precedent, which I thought was kind of interesting. He says we can read it more broadly or narrowly depending on whether it's consistent with original understanding. So I think there's a lot of interesting thinking going on at the court with what to do with some of that older precedent.
Yeah, I can jump in there on that point. I mean, in part, obviously, that comment is based on an empirical claim, right? What is the number of Supreme Court cases each year that overturn earlier cases? And this is something that CRS tracks, right? So I mean, I pulled up the website where the Congressional Research Service maintains a chart of every Supreme Court case that overturns a previous one. At very top of the list, of course, is Loper Bright overturning Chevron. And it's in chronological order. So scrolling through, right there, according to CRS anyway, such an overruling happened one time in 2024. It happened, they don't have anything for 2023. Dobbs is their only case in 2022. They have likewise 2020, 2021. It's a single case each of those years. 2018 and 19, the court was a bit more active, but then before that, again, you go several years at a time, 2 or 3 years at a time without any overrulings. So, I mean, comparing the past 10 to 15 years to timeframes in the rest of the list, I think looking at the 70s, the 80s, or obviously, if you go back even beyond that, where the Civil Rights era, the New Deal era, at least from this like formally overruling, right, acknowledging that you're overruling precedents, this court actually seems to be slower than it seems, and I think is actually doing less than it's publicly than I think most of us would be surprised actually in seeing how few precedents, particularly compared to earlier periods in time, the court again, at least based on the CRS survey, has actually overturned.
That's the beautiful thing about data. Does anyone else have comments? If not, I will move to the next audience question.
I'll just throw out because it's it's a cert petition that's pending. Court hasn't acted on it yet. The response brief hasn't been filed, but NRA versus Vulo was decided last term. First Amendment case that was 9-0 out of the Second Circuit, basically holding that job owning by some government officials in New York State, violated the First Amendment. Based on the allegation in the complaint, the case went back down to Second Circuit, granted qualified immunity, and the case is going back up to the Supreme Court. It's interesting because on the one hand, it doesn't the cert petition itself does not ask the court to overrule qualified immunity or reconsider it at all, but it attracted a lot of amicus attention. And that was a lot of the fire in the amicus briefs was focused on, especially some recent scholarship about maybe like the fundamental premise of qualified immunity was just flat out wrong because the court thought that there wasn't text that actually was text in the original 1871 statute. So it'd be really interesting to see what the court does if it's willing to kind of go there in this case that again doesn't quite present it, but it's definitely lurking, and the court could get there if it wanted to.
Great, thanks, Joel. So the last question is equally broad, but I think it's framed in reference to Trump v. Slaughter as well, and that has to do with whether the court hears a case on the emergency docket or the merits docket, or it's moved over, and sort of what are the implications of that. And so any comments on that in reference to your specific case or the term more generally?
I mean, I'm happy to jump in if no one else sees that. Obviously, the emergency docket, so-called shadow docket, as Professor Bode would have us call it, was directly implicated in Slaughter. one of the big controversies that arose this term concerns the circumstances under which the Supreme Court should stay lower court rulings. And I think that in Slaughter and some of the other cases that I discussed, Wilcox and Boyle, that controversy really came to a head precisely because part of the point of emergency stays, or in the extreme case injunctions pending appeal, part of the notion of this is that it isn't supposed to be something where just because the lower court got something wrong, therefore the Supreme Court is going to step in. Part of that analysis entails, is the court likely to grant certiorari? The reason why this issue was so controversial in Slaughter and some of the related cases is because the lower courts were basing their opinions, right? The district courts had entered injunctions based on the strength of Humphrey's executor, right? And so certainly there was no question, right? A district court is not free to decide for itself either, I don't think this Supreme Court ruling is binding anymore, or I think the current court is likely to overturn the ruling, right? The Supreme Court has repeatedly said, we retain for ourselves the prerogative to overturn our precedents. It's unless and until we do so, the lower courts have to follow those precedents. So I think the initial issuance, whatever you think of the Article 2 question, I think the initial issuance of injunctions in the Slaughter case and some of these other cases were on solid ground insofar as the lower courts were doing their job of applying Supreme Court precedent, of following Supreme Court precedent, which then raises the question, if the court wants to overturn a precedent, if the court doesn't want to apply a precedent, is it appropriate for the court to do that for the first time in the context of one of these emergency appeals, right? So the argument in Slaughter wasn't necessarily that the lower court got this clearly wrong, or that under current law the government is likely to succeed, though again there are theories on which that could be the case. Rather, right, a big part of the reversal was, we think we're likely to hear this case. We think there's a good chance we're going to overturn Humphrey's executor when we hear this case. And so therefore, we're going to grant this emergency relief. We're going to stay the lower court injunction. And so this dispute over, can the court change the law in the course of a shadow docket ruling? Or more, I guess, from a normative perspective, should the court be saying we're likely to change the law in the course of a shadow docket ruling? Or should those requests for emergency relief be limited to currently existing black letter law, right, based on precedent as it exists as of that time? And then, of course, if the court is changing the law or suggesting that a change in the law is likely to happen, what does that mean as a matter of precedent then, right? Should lower courts, in considering their own requests for stays and considering their own requests for preliminary injunctions, should lower courts then be applying actual Supreme Court precedent, or the Supreme Court's more recent prediction as to what is likely to change or what is likely to soon become precedent? You very quickly get to second and third order questions in terms of the proper way for lower courts to approach emergency relief. So I don't necessarily think the court's ruling on the merits in Slaughter is going to address that issue. It's certainly not the right posture to address that issue, but it's something that the court's recent activities on the shadow docket has created.
Yeah, certainly. I think, with respect to Ham versus Smith, which is the case about whether the proper evidentiary approach to address mental incapacitation, it kind of highlights that you can't put undue pressure on the emergency docket versus the merits docket distinction. Because, for example, the Supreme Court's merits docket, the justices ruled in favor of death row inmates 3 times just in the last term, yet almost every stay of execution on the emergency docket is routinely denied. And so I think, it's not such a clear dichotomy, but in some cases, those insights can be quite helpful.
And there is some movement in recent terms that the court seems increasingly open to scheduling matters that come in on an interim relief motion or an emergency relief motion for argument and deciding them after argument. I think the court finds that very helpful. They have been whether on their own initiative or in response to some of the criticism about the way the interim orders docket has operated, they've been giving more fulsome explanations, even if just a few pages, than they had previously done when you would get the single line docket entry, the order of the court below is stayed. And as they're trying to work out those longer opinions in these emergency contexts, I think they find it very helpful to have full briefing coming to the court as a whole, then being argued, as compared to the emergency cases that come into a single justice who's then referring it out to the rest of the court on a memorandum basis. And all of the court's internal conversation about the relief is taking place through memoranda without conference, without oral argument, and even without the parties having the opportunity to weigh in on the merits of the dispute, freed from the separate procedural multi-factor requirements of emergency relief itself. So I think the court is finding it more useful to set these for argument and fold them in with their regular merits cases.
Yeah, definitely. Thank you. I think now is the time that we will turn it back over to Nate.
Thanks, Jill. Thank you very much to our panel as well. Wonderful, insightful session. Appreciate your time this afternoon. For our audience, your feedback would be appreciated at info@fedsoc.org. Until next time, thank you all for joining us. We are adjourned.